How could you deal with it in a courtroom? It couldn't. There's no way you could have dealt with that in a courtroom and created the healing that happened by the interaction between the young man who had killed their son in a road accident. And I've heard of similar experience. I helped Jessalyn Nash in Sonoma County to get conferencing started there, north of San Francisco. And they started getting vehicular manslaughter charges, and they had one there where the young offender shared how traumatised he was by the fact he'd killed his family's children in a car accident. 3 children were killed. And that he felt like committing suicide. It ended with the parents of the children that were killed holding him and saying, "We don't want another death here. We understand the hurt you've had, and you understand the hurt that we've had, and we need to grieve together." So they said prayers together. It's this sort of healing that I've witnessed over and over again in this process that brings these emotions to me today. Another case I want to share with you is a young girl who I went and visited as a victim, and she was a victim of 3 times rape. The offender was a 16-year-old who had been taken to paedophile meetings by his mother since the age of 5. The police reduced the charges to 3 times unlawful sexual connection. Now, it was very important in this case for people to understand that the offender had no normal boundaries, didn't understand any normal boundaries. The young girl who had been a victim of incest from as long as she could remember, and this young lad were placed in the same residence. And when he made his sexual advances, she coped with it the way she coped with her incest. She shut down her mind and escaped to somewhere else and just let it happen. So because she'd done that the first time, he came back and back. When I met with her, she said, "I don't want to be in the same room with him, but I want to see the conference." I thought, well, that's a challenge. She's 14 years old, wants to see the conference, but doesn't want to be in the same room with him. I thought, oh, I've got a video camera. There's a TV in the office. So I set up so she could sit in the next room and watch the conference on television. And she had the support person with her and a social worker with her. And because she wasn't in the conference itself, she had a representative in the conference. During the conference, she wrote 3 letters for her support person to read out. Her first one is, "You're not taking enough responsibility for what you did to me." The second one was, "I don't want him to lose his job. I want him to keep his job because I want him to pay for my self-defense lessons." The agreement that came out of the conference was that social welfare would pay for her defence lessons, but they couldn't pay for the friend that she wanted to go with her. So the offender paid for the friend to go with her. And the third one that she asked for in the third letter is, "I want parts of this city that I can go and know that I'll never ever run into you, that I can socialise, mix." So this, again, was a very, very serious charge. It would be extremely unusual for it not to be an incarceration. And the police weren't confident in making the decision. They agreed with the outcome, but they said, "Allan, if we take this as an agreement, then it's on us. What we'd rather have is a non-agreement and have the judge make the decision." So what the conference agreed to, it agreed to not agree, but agreed that the lawyer that was representing the offender could write down the plan and present it in court, and the police said they wouldn't challenge it. I've seen the law manipulated to get good outcomes. Another case was an aggravated robbery where the young offender went back and the person that was looking after the garage was lying on the floor as instructed, done exactly what he was told, what his employer told him to do. This boy was told to go back by the adults and stomp his head in. So he did. He went back and stomped his head in. This victim was an A-grade student at Victoria University and would never ever do better than B from the rest of his life. The father attended the conference on his son's behalf. And his father said, I want you to go to jail for what you did to my son. I really believe you should go to jail for what you did to my son. But I don't want you to go for too long. The next thing is the conference discussing which is the best level of court to put it in to get the right outcome for the father. If you put it in the district court, they would see it at the most serious end of what they do and probably give them 5 years. You put it in the High Court and they'd compare it and probably only give 2 years. So the conference agreed not to, for a non-agreement on the grounds that his lawyer would lodge it in the High Court. Some pretty powerful stuff going on, way beyond just restorative justice. Another case, and this will be the last example I give you, was where the victims and everyone agreed this young person had needs that needed to be addressed before they could be held accountable. And the social worker said they could get them in this program, they'd be in that program for 3 months, and then could we deal with the restorative justice stuff, putting things right with the victim. And the conference agreed, and that was taken to the judge, and the judge said, no, I don't agree, I don't want it on remand that long. I'm directing you to go back and run the conference again. So I went back and told the conference, this is the judge's decision. So they debated it, and then they come up and said, we actually agree with our first decision. And so did the police. So the police withdrew the charges out of the court so the judge wouldn't have a say. That plan was completed perfectly. The young person knew the opportunity they were being given and they stuck to it. We're extending the youth of youth justice into many fields, as I've mentioned, and we're looking at, there's a place for restorative justice and working with young people when they're incarcerated. There's a partnership for youth justice and managing their release and their transition back into the community. Because if we don't handle that, we just leave them in another position of being vulnerable to go back in. And right now we're piloting a process for doing that in New Zealand, and I have the lead on it. And so far it's working very well. But we're using conferences to plan the young person's release, and then we're using them 2 weeks after release to make sure everything's on task, everything that's said is done, being done, and then we're running them every 2 months to make sure. Now, imagine a partnership of people working together like that against the sole probation officer trying to manage a caseload of people. Social workers, probation officers are mainly a 9-to-5 job. These young people need support way beyond that, especially in evenings and weekends when they're most vulnerable to get into trouble. Family group conferences are bound to partnership up community resources with professionals to achieve that. And that's one of the strengths of capturing the resources of the extended family and the community at large. We can virtually put 24-hour support around young people. The judges in New Zealand that were working in the youth court saw the imagination, the options that were coming out of this. And so they formed a judicial pilot to advocate to get it into the adult system. Now, judges are not going to do that unless they feel there's some real value in doing it. And that led to the Sentencing Act in New Zealand to allow restorative justice in adult court proceedings. Now, restorative justice is not an alternative to the normal justice process. It's been developed over centuries. But what it does very well is gives the court an extra set of tools. It helps work out in a far more comprehensive way of which ones actually need to be before a court, so that the court's time is not burdened with unnecessary cases, and they can put their specialist area into greater depth with the young people or the adults they're working with because they've got more time. And so the courts have become more effective at their work.